Brooklyn, New York.
That's it? Yep.
All set.
Okay.
Set up time. Ready?
Yeah.
I thought the Buyer Committee rather uncovered the fact that perhaps the most frequent error that was made was in not appointing a special committee. And I ought to say that because there is some concern on the part of other witnesses we'll hear from that any system in which judges is going to be loaded against judges, at least one of the misconduct proceedings in which a special committee was not appointed, the findings were that the judge had engaged in misconduct. That the Chief Circuit Judge, an acting Chief Circuit Judge, found that the Chief Circuit Judge had engaged in misconduct, but no committee was appointed. Dr. Richard Cordero. Dr. Cordero, I have read your written testimony. It will become part of the record of this proceeding and will be transmitted to the other members of the committee. And if you want to take 10 minutes now to summarize your main points or add other points, go ahead.
Thank you, Judge Winter. I would like to add a statement that I have prepared because it has some graphics, and I'm going to be making reference to them, and it would be useful if you had a copy in front of you.
Fine, that's fine.
Should I bring it to you?
Yes, and we will make that part of the record also. Do you have an extra copy of it?
Yes.
Would you give a copy to Mr. Sachs, please?
Yes. You started the hearing this morning by asking a pertinent question. You asked whether the rules should be focused on the chief and circuit judge or on the complainants. And it seems to me that the question is actually irrelevant because the point is whether the rules will be effective as they are now. The rules as they have been drafted simply mirror the current rules that have been in place for almost 27 years. And these rules have proved to be completely ineffective. And
well, I'm not sure. I agree with that. I think that the rules about when to identify a complaint, the rules about kind of inquiry the Chief Circuit judges ought to make, the definitional sections, all involve materials that are hardly clear on the face of the statute and hardly clear in what might be called the common law that is developed under the statute.
Well, the fact is that the rules of now, as far as the substance goes of the process of complaining against the judges, they are the same as the current rules.
Well, in reviewing your testimony, I was struck by the fact that your main complaint is against the statute. This is not the statute sets up that procedure about filing a complaint and who deals with it. This hearing is not about changing that. This hearing is about rules that are proposed to implement that statutory scheme, so that with all due respect, the committee had no power to propose rules that would do the kind of thing that you seem to want, which is to get judges out of the misconduct procedure, and hardly clear in what might be called the common law that is developed under the statute.
Well, the fact is that the rules of now, as far as the substance goes of the process of complaining against the judges, they are the same as the current rules.
In reviewing your testimony, I was struck by the fact that your main complaint is against the statute. This is not the statute sets up that procedure about filing a complaint and who deals with it. This hearing is not about changing that. This hearing is about rules that are proposed to implement that statutory scheme. So that, with all due respect, the committee had no power to propose rules that would do the kind of thing that you seem to want, which is to get judges out of the misconduct procedure, except as defendants.
Well, the fact is that in the statement that I submitted on August the 23rd, my focus was the rules. It was not the act. I submitted commentary of specific rules, and they were addressed to their ineffectiveness. The rules as they stand now, they do not change the players or the procedure. They do not make the complaints available to complainants and to other people. The complaints are not rendered public. They do not require that the complaint about a judge take cognizance of the complaint, because the procedure as it stands now, it's simply for the clerk to receive the complaint, to send it to the chief circuit judge, and then to send it to the complaint about the judge and to his chief judge. They don't have to do anything whatsoever with evidence. They can simply ignore that a complaint was ever filed against them, because they do not have to take any action, because the chief and circuit judge overwhelmingly is not going to do anything whatsoever about the complaint. In prior report indicated that in some circuits, it is the clerks that read the complaints and even prepare an order to be signed by the chief circuit judge. So it is not the judge that treats the complaint and that takes action on them. It is relegated to a matter that can be handled by simply clerks. Now, the rules do not provide any adversarial confrontation between the complainant and the judge. So that there is a system completely different from the system that applies to anybody else that complains against anybody else. That is, aside from complaint, what we have in the system of the courts is a person who is the complainant that complains against other person who is the defendant. And everything happens in the open. Why is it that in the case of complaining against a judge, there must be such secrecy that even the name of the judge must not be known, that the public must not know the name of the judge? We see in respect to the other two branches of government, the executive and Congress, that all sorts of complaints are made against the President of the U.S. All sorts of complaints are made against members of Congress. The Republic doesn't fall apart because people complain against the President of the United States or against his secretaries or against other members of the executive. The Republic doesn't fall apart because people complain against a member of Congress. Why is it that there should be such a secrecy when a complaint is filed against a judge? You indicated that there should be independence on the part of the judges so that they may not be afraid when deciding on controversies put before them. Why would they be afraid because somebody complained against them? Those are two different things. A person can complain against a judge and he can still decide however he wants, the same way that the President of the United States takes decisions and everybody complains against him, and he simply goes about his business of performing the duties of his office. The judge could do the same thing even if a person complained about him and not only his name became public, but also the complaint itself, the substance of the complaint. That would eliminate the secrecy that shrouds the procedure right now, which leads to the supported complaint that secrecy is simply a way of supporting what the prayer report itself called the guilt favoritism, which means that judges are handling complaints against their peers and they are doing nothing about it. And I want to bring now the evidence that I have here, because this evidence is produced by the Administrative Office of the U.S. Courts. This evidence is produced by the reports that the circuit courts have to make every year to the Administrative Office of the U.S. Courts. They have to report on the number of complaints that have been filed against judges every year. They are published in the Judicial Facts and Figures. They're also published in the annual report of the Director of the Administrative Office of the U.S. Courts. Now, I have examined those statistics that are available on the internet for the last 10 years, and I have presented them in the graphics that you have in front of you. You will see that in the last 10 years, since October 1996 to September 2006, 7,462 complaints were filed. They were filed overwhelmingly by complainants. Out of those complaints, you will see there that only 5 complaints were filed by the Chief Circuit Judge. And nevertheless, he's a person who works with all the circuit judges. He attends committees. He attends meetings of the Judicial Council. He attends also annually, actually twice a year, the meetings of the Judicial Conference of the United States. He sees what people do, what they come into, what they do and say when they go to judicial junkets and have no more inhibitions. And nevertheless, in spite of all that insider information that he gets, all the 13 circuit chief judges in the last 10 years have identified 5 complaints. 5 complaints. Now, we have the professor spent time here
as I understand the draft proposed rules, they're intended to meet the criticism that chief judges have been too reluctant to identify complaints and to appoint special committees.
Excellent. So let's go back.
Your problem is that you think the chief circuit judge shouldn't be the one doing this.
That is one of the...
Yeah, but that's really beyond the scope of this hearing.
No,
That's in the statute.
No, Judge Winter, I would like again to go back to the evidence because whatever comments I may make, they may be irrelevant. I want to...
The evidence is not only in your document, the evidence is in the Breyer report too. And I take it the conclusion you're drawing, it's not an illegitimate conclusion that this should not be a self-regulatory process, that it shouldn't be done through the judiciary itself. I think that's a feeling that you share with others. All I'm saying is that you're really not commenting on the rules. You're making comments suggesting that the statute itself ought to be amended, and my committee has no jurisdiction whatsoever to do anything like that.
Well, for one thing, your committee could examine the evidence that is available and state whether applying the rules as they are drafted now would change in any way the situation that we have right now. You indicated whether the chief circuit judge should be one identifying complaints. Well, look what happens when they do identify complaints. On page 3, on the first graph, you see that for 9 years, circuit chief judges had identified only 5 complaints. Then, all of a sudden, in 2006, they identified 88 complaints. That is incredible. Now, what happened with those 88 complaints? Absolutely nothing. They were dismissed the same way all other complaints were dismissed. You can see also something that is statistically impossible. For 9 years, the number of complaints filed by complainants hovered.
I'll ask you once again, what is it that you want the rules to do to remedy your perception of something going wrong?
I will address that question because I think it's a fair question. I would like to simply to finish with this analysis of the statistics because
you've had almost 20 minutes. I'll give you another 5 minutes, but you certainly have to get to the rules and tell me something, tell the committee something about what rules you think ought to be drafted to implement the statute rather than attacking the statute.
Well, Judge Winter, I am not attacking the statute. I am attacking the usefulness of the rules. You began the hearing by asking whether the rules should be addressed to the chief circuit judge or to the complainant. And I am indicating that it doesn't matter. It won't change anything. Also, I would like to point out that the professor has 55 minutes to present a...
You are not going to get 55 minutes, Dr. Cordero. The professor was engaged in a useful discussion of the draft proposed rules. I have yet to get any concrete suggestion from you as to how the rules ought to be redrafted.
The rules should be redrafted in such a way that complaints are made public, that the secrecy protecting judges is lifted, that the public knows why is it that people are complaining so that one can establish a pattern of conduct on the part of judges, either on one judge, because there are several complaints are filed against him, or on the part of judges because they engage in coordinated judicial wrongdoing. And why would they not do that if there is no possibility that they would be disciplined? In this graph that I present on page 3, of all the complaints that were filed during 10 years, 7,462, how many judges were disciplined? 9. 9 judges of all that. That is less than 1.1% That means that however much we discuss here about the rules as they stand now, they're going to be fundamentally useless because they mirror the rules that are now in effect, and therefore they're going to have the same effect as the current rules. Based on the principle that people say that the hallmark of irrationality is to do the same thing while expecting a different result, well, that applies here. I have more specific comments against on the rules, and I would like to be able.
Well, I will ask you.
You see how many people are here? It is because the committee put the announcement of the hearing on only one single website. Even the website of the Supreme Court does not contain a notice of this hearing.
File a supplemental statement with the committee. You are welcome to do so. But thank you. That concludes your presentation.
Thank you.
Next witness is Francis C.P.
Hello, my name is Francis Kanisha, and I'm a producer. And
I apologize for mispronouncing your name, Mr. Kanisha.
That's quite all right.
I want to welcome you here today. I have looked over, I've read your statement, and it will be part of the record of these hearings. And if you'll have 10 minutes to summarize your statement, to which I will add any interruptions that I make and time for that. Go ahead.
I thank you. I'm a producer. I take an interest in these hearings on behalf of the American public. And since we are a trickle-up government that it's supposedly represented by the people believe that they have an interest in any kind of judicial oversight process. I start with a definition of constructive fraud. And constructive fraud by Bovier's Law Dictionary, 1856 edition, is as follows. Constructive fraud, a contract or act which not originating in evil design and contrivance to perpetuate a positive fraud or injury upon other persons, yet by its necessary tendency to deceive or mislead them, or to violate a public or private confidence, or to impair or injure public interest, is deemed equally reprehensible with positive fraud and therefore is prohibited by law. And since we only have 10 minutes, I'm going to cut out a lot of my presentation here and get to the point that in relation to the Ninth Amendment of the Constitution, that the Ninth Amendment lends strong support to the view that, quote, unquote, liberty protected by the 14th Amendments, 5th and 14th Amendments from infringement by the federal government or states is not restricted to rights specifically mentioned in the first 8 amendments. It was said that this category of fundamental rights includes those fundamental liberties that are implicit in the concept of order, liberty, such that neither liberty nor justice would exist if they were sacrificed. That was in the Palco versus Connecticut case. I'm not going to state the numbers because there's not enough time. Please, I ask the public to refer to the actual testimony on record. These hearings on judicial conduct...
Do you have any comments on the draft rules? I mean,
Absolutely. I agree with Dr. Codero in that simply the omission of rules or the surrounding facts around concerning the rules are basis for a testimony. And if the judiciary cares to hear public comment, now I'm not a lawyer, but I can tell you what I've heard from the American public at large. So if I may continue.
oh, sure, you might continue.
Okay. These hearings on judicial conduct stem from the 1980 Judicial Act, which originally wasn't intended for, but did manage to immorally and by definition fraudulently put judges above the law. For 27 years now, those who look to this branch of government for relief have been disappointed time and time again. They have been exacerbated in many instances by judges who threaten the very lives of those who petition their courts for relief. And our own former U.S. Attorney General, John Ashcroft, condemned the judicial branch of government by characterizing this branch as organized crime. You can refer to the document on record as to his exact quote. This is just the very tip of a very large iceberg, which each day gets worse, not better. Americans simply want the Judicial Conference to do something positive, act responsibly to remedy the harsh criticisms the judiciary has weathered. The Judicial Conference may have interest that not only has John Ashcroft's opinion on such judicial crime, but other officials have as well, including but not limited to Chief Judge Edith Jones at the Fifth Circuit Court of Appeals as follows. Corruption, quote, corruption in the agencies charged with enforcing our laws not only threatens communities by allowing dangerous criminals to roam free, it also undermines the confidence of our citizens in law enforcement and the criminal justice system. The same is true with respect to judicial corruption. We must all in our own countries lead the fight to ensure integrity within our police and judicial systems. Now, concerning these rules today, many in the public have expressed to me on behalf of my television series In the Interest of Justice that this document in itself shows an appearance of impropriety. Canon 2 implies judges shall avoid impropriety and the appearance of impropriety in all activities. That would include the Judicial Conference activities concerning complaints against judges. The impropriety exists when judges are judging the judges. People perceive a lack of true oversight when men are the judges of their own causes and seem to form an illegal nobility. The recommendation from the general public is that an impartial tribunal of citizens should be the judges of misconduct accused of a judicial officer. And I go on skipping some paragraphs. The legal statement shocking to the universal sense of justice. Judges should not adjudicate hearings on complaints against a judge because it creates a quid pro quo situation where judges would tend to keep other judges off the hook for accountability. The Judicial Conference must incorporate, quote unquote, the doctrine of judicial restraint and therefore accept restrictions on conduct that might be viewed as burdensome by ordinary citizens and should do so freely and willingly. And that's out of Canon 2, as you well know. Having the gumption to produce a document as the one above shows the willingness of the Judicial Conference to forego the black letter of judicial ethics in order to maintain control over the rules and keep involvement by the public out of the process. The Constitution in Article 1, Section 9, Paragraph 3 states, no bill of attainder or ex post facto law shall be passed. The fact is that it is perceivable that the rules governing judicial conduct are, in all practical effect, a bill of attainder or ex post facto law. And what I mean by that, the Constitution does not grant the kind of secrecy that the Judicial Conference is giving its judges and the judiciary through the Judicial Conduct and Disability Act of 1980. And it does so by assigning a commission of partial parties to decide in favor of their peers. At least the appearance of that to the public, from what I gather from talking to at least just hundreds of citizens around the country. Due process rights concerning complaints against government agents must fairly be decided by an impartial jury of citizens because that is what is secured by the Constitution. And I cite some laws on the record that show reinforcement of that concept. Given that we philosophically are a trickle-up government, whereby the government is by the people, Rules 11 onward accomplish just the opposite, a nobility. Quote, sovereignty itself is, of course, not subject to law, for it is the author and source of law. But in our system, while sovereign powers are delegated to the agencies of government, sovereignty itself remains with the people by whom and for whom the government exists and acts. And that's Justice Matthews of the U.S. Supreme Court in the case of Woe versus Hopkins. And my main point today, if I had to emphasize a point, is that the problem is obvious when 99% of all complaints against judges are summarily dismissed. The public perceives a 99% dismissal of all complaints as a system that is broken. The report, Implementation of Judicial Conduct and Disability Act of 1980, a report to the Chief Justice by the Breyer Commission, concluding that the system works well, is perceived as nothing more than a farce by the American public in light of such a high statistic for dismissal of complaints or ruling against complaints. The American Bar Association has shown through its polls that public confidence and trust is at an all-time low. And it's less than 30%. You have to look at the different ratings they make, but if I had to average it, it's running about 30%. So you can argue 40%, but in some areas of law, it's running at 20% confidence in the judiciary. And the Judicial Conference must note these very pertinent polls done through the American Bar Association. There's a problem with the judiciary in acknowledging its imperfections. Sooner or later, a blowback effect will occur against the judiciary for suppressing the problem of judicial misconduct. America is demanding constitutionality by all three branches of the government. The Judiciary Act of 1801, Section 31, 6th Congress, Session 2, Chapter 4, is a preemptive congressional act section that prevents the judiciary from undue rulemaking. It is a legislative act that prohibits making regulations that are repugnant to the Constitution for the public that doesn't know what that means. Provided, and the quote is in the ruling, quote unquote, provided always that they are not repugnant to the laws of the United States. The draft rules of the 1980 Act are repugnant in that they don't afford an impartial hearing concerning complaints against judges. And I'm going to cut through a lot of this again, because I know I'm feeding upon the time of this hearing.
Are you suggesting that the committee had power to provide decision makers other than judges in its rules?
Well, I think that the Judicial Conference is a very powerful agency, and that what they do,
It would require action by the Congress of the United States, would it?
well, obviously, the act has to go through the Congress. There has to be oversight, since it is a congressional
What
act.
you're suggesting is something that simply, you may be right, but what you're suggesting is something that would require legislation. It's totally beyond the jurisdiction of this committee.
Yes, but rulemaking should not be repugnant to the Constitution of the United States. And that's the appearance of impropriety for some of these rules is apparent to many Americans. When the rules...
I can well understand why there is doubt, why there is skepticism about a process, as there always is about any self-regulatory process. I can understand that, but these rules, this committee does not have power to depart from the statute. And the statute sets up a system that you don't like, and I think you're just in the wrong forum, that's all.
Well, I think that whatever happens with the judiciary reflects upon the judiciary committees at both the House and the Senate. And there should be some kind of crosstalk. In fact, if I may, the report, Judicial Independence, Interdependence, and Judicial Accountability, Management of the Courts from the Judge's Perspective, Institute for Court Management, Court Executive Development, a very prominent report of May 2006, just a little over a year ago. Program Phase 3 says on page 11, to answer your question, Justice Winter, a review of the separation of powers doctrine and the interbranch conflicts created will enhance the understanding of judicial independence. Separation of powers does not specifically mean creation of a barrier that positively presents any connection or contact between the branches. Preferably, it finds expression mainly in the existence of a balance among the branches, powers, in theory and in practice, that makes it possible interdependence in the context of specific reciprocal supervision. Although the judiciary is an independent, co-equal branch of government, the constitutional doctrine of separation of powers allows some overlap in the exercise of governmental functions. This overlap is sometimes referred to as the doctrine of overlapping functions. So I think that pretty much explains that the judiciary itself, by its highest judges, through this report, communicates to the world that there should be some sort of interbranch communication.
Okay, would you wind up, please?
Winding up. The American public, from my observance, wants the Judicial Conference to add to the rules the following. Complaints are too often ignored by the Judicial Conference, and it hardly ever gives notice to the movement. The citizens demand that once a complaint is filed, an index number must immediately be issued by the ruling authority, and that an official hearing must be granted within 30 days. And that would be helpful. It would actually resolve a lot of the problems that Dr. Codero has brought up. And that's basically, I just conclude now with that the finding must address each of the specific allegations and be released publicly and put on the record. Canon 2 states public confidence in the judiciary is eroded by irresponsible or improper conduct by judges. A judge must avoid all impropriety and appearance of impropriety. A judge must expect to be the subject of constant public scrutiny. And so that's par for the course that the public expresses its opinion through me today. And I also want to address one last point before I go that Dr. Codero alluded to, and I would like to say that the rules are dependent on the qualifications that the Judicial Conference has set for misconduct. However, many in the public believe that breaking the law in itself is grounds for misconduct, and that there's no discretion to ignore jurisdiction, and there's many functions of a judge where discretion does not come to play, where the judge must follow the law, and time again, judges are not following the law. And what I have experienced, and what other emeritus have experienced, is then the other judges rally to protect the judge who broke the law. And then it becomes a conspiracy, an ever-building conspiracy. And I have experienced this firsthand. I'm not here to talk about my case, but I tell you that I have experienced this firsthand, and it goes on and on and on. And my next step is to file some complaints with the Judicial Council, and I wonder what's going to happen. So on that note, I thank you very much.
Thank you. Thank you very much.
Thank you, Justice Winter.
That concludes the hearing.
Will you
Thank you all
permit
for
further
coming.
testimony from the public? I requested 3.5 weeks ago to be permitted to testify. I wish to address specifically the rules.
I know of no such request.
I have
and
it right here.
I can't
Email
entertain
from
it
the
now.
Judicial Conference.
If you will,
from the Administrative Office, rather.
If you listen to me, if you will, anyone who feels they asked to testify, and I would like to see the documents in which you asked to testify and to see that they were filed in a timely fashion.
I have it right here.
Thank you. You can send them to me.
And I have a draft statement addressed to the rules, specifically the violations of the statute reflected in the rules with respect to merits relatedness
Comment
and
period
confidentiality.
on the rules is still open. It is open until October 15th. If you would like to comment on the rules, please do so. We welcome it. But I'm not here to get in an argument with the audience, and I'll have the room cleared if that's done.
The draft rules contravene the statute with respect to confidentiality, because the statute does not require confidentiality of anything but the special committee proceedings. And as you know, it's only a negligible percentage of
special investigative committee.
in 25 years.
In 27 years.
Since
19 years.
Right. So actually, the statute does not require confidentiality. This is something that has been broadened improperly by the federal judiciary to encapsulate the whole process and to prevent the public, Congress, from understanding what a scam the judicial complaint mechanism is as proposed in the federal judiciary. Now, that is one aspect of what I wish to point out today with respect to the draft rules. The other aspect is, as you know, all of the complaints are not only dismissed by chief judges, and then those dismissals are affirmed by the judicial councils, but the overwhelming majority of those dismissals are on grounds of merits relatedness, that they are related to the merits of a decisional procedural ruling. Well, not only is it a cop-out, but you need to know, and it's been incredibly, it's been overlooked and concealed, that the statute does not require the dismissal of complaints that are arising from decisions and procedural rulings. The language of the statute is may. It gives discretion. It is the federal judiciary, by its draft rules, that now have said must. They must be dismissed, and that replicates similar language in the former and extant illustrative rules adopted by the circuits, where the language is will dismiss, shall dismiss, Well, the federal judiciary is making mandatory what the statute gives discretion to the judiciary to examine. Obviously, every case involves decisions, rulings, and
That's what the prior committee acknowledged.
right. What the federal judiciary does is make decisions and rulings in cases. It's with respect to the conduct in those cases that complainants seek review. To say that no, they cannot be reviewed in a disciplinary context is wrong, is not correct. It's not authorized by the statute. And the important consideration always is not to be misled by the federal judiciary's claim that, complainants are whining and complaining about decisions which are erroneous and that they think are wrong. No, complainants over and again, as you know, they're not complaining about wrong decisions. They're not complaining about erroneous decisions. They're complaining about corrupt decisions. They're complaining about decisions that not only fly in the face of controlling black letter law, which, as you said, gives them no discretion at all, and they're disregarding their mandatory duty to act under rules of law, but they are falsifying the facts on which the law depends in their decisions.